I am not telling as a patent here, because whatever you are submitting, that is your invention, that will be qualified to be patentable, qualified to be a patent based on, say, our review, attorney review, patent office review, and further procedural aspects. So let's say how we have divided the invention review process. I will just show you in next slide. So just let's say you are submitting an invention, that is the output of your research, based on that whatever research output you generated, that research output can be a potential research paper, but before publishing that research paper, we generally suggest it has some potential commercial values and also some potential commercial value that can give you a return. Just like say we have designed our logo for this purpose, just like say we have put one side prize money, another side we have prize money plus IP. That IP will only IP will just like say will only that if you take the prize money only, that prize money will be one times, and if you take IP, after taking IP also you can get prize money out of that. So IP will not prevent you to ultimately get the benefit of prize money, get the benefit of other reward. But say you have to take IP first, then have to proceed for the others. So for that reason we say you are submitting an invention in the form of an extended abstract, that whatever we have designed in our invention disclosure form and already available in our patent portal, anybody can log in that patent portal and can submit that in the form of an extended abstract. When we are telling extended abstract, maybe you are not providing all details in that part, but even we suggest in abstracts also contain information all together, just like in the basics form and specific forms. So that in extended abstracts also you are submitting your invention in the form of a, let's say, a composition, in the form of a, say, process, in the form of a product, in the form of a systems, or in the form of, say, a combination of product along with the process that you are highlighting in the extended abstract form. So now the invention will be considered to be converted into a patent. So there is, I think there is procedural aspect. So before going to the procedural aspect of the patent office, we have designed our review process for I think benefit of the, say, persons, means inventors, or benefit of the, just like say sometime in the economical sales, we considered how can you minimize the transaction cost. Just like the transaction cost minimization happens if you just somehow decrease the time with reference to that part. So that way review process somehow helping the inventors to design their invention, and also just like say they are also reducing the time. Sometimes attorney takes long time. This time when we are reviewing and giving that the ready-made product to the attorney, they are also even ready to file within 1 or 2 days. So that is the benefit. Somehow decreasing the delta T time on that part. So that is the benefit for the inventors. And so just like the invention, whatever you are submitting, we are reviewing the two aspects. Whatever Professor Shah has already highlighted to you, just technical review and say patentability reviews. Because this is, you are considering your technology part, how you are converting into an invention. Just like say, I teach an introduction to IP law class, I put it like this way, what is invention? I specified that it is something like a product or process. It's a product part or process. But how will you convert your product or process or product along with the process in that form of extended abstract? That we try to review based on two part, technical review part. Technical review part, generally we look after the feasibility, whether just like say sometime you may say that okay, man can climb in air, which is only simple 2 hands. So that whether it is technically feasible. So that like this way. So a lot of people may put it like this way, that sometimes just the inventor is the best person to judge his invention, but till to highlight that aspect, we just check for the feasibility, we check for the utilities. Just like say one of the criteria of say invention, and I told you if you don't get any commercial return out of the patents, then the I think basic objective of the patents may not be fulfilled. So considering that, we also take care of the utility aspects. Just like what will be the utility with reference to that extended abstract to convert it into a patent. Because also you understand there are cost involved with reference to each procedural steps also. So that we generally check utility, feasibility. Here the benefit to the inventors also. What way? Just like said, this based on technical review process, you are thinking about that my invention having utility in one direction, the review process may suggest you that, okay, your invention can be used, okay, you are using the sensors, specifically your invention is some sensor, you want to use the sensors for flue gas conditioning systems, but that sensors can also be used for any chemical process simulation systems also. That way, that let's say, just like our technical review group will highlight and suggest that how based on that also you can enlarge the scope of your inventions. Then also they can, that way you can change the scope of your invention based on their feedback. So that way that you can say, somehow in some cases you enlarge your scope, some cases you diversified the scope, that can also be came up from the technical review process. Then we also separately also review, another group team members are involved with the review of the patentability, just like say for patents of an invention, we require 3 criteria to meet. So what are the we generally review for novelty? Just like say there should not be no existence of any prior art. The prior art means in the form of prior publications, prior use, prior knowledge, prior working. Just like say if you think about, just like you have already published your paper 2 years back in some Elsevier journals. Now you want to convert that in the form of a patent. That will not be considered as a patentable invention because already you have disclosed your invention in the form of a publication and it will be considered prior published document. Even let's say you escape our review route, patent office again will examine the novelty. Again, the patent office, if not, then again it will be put up for opposition proceeding. In India, we have 2-tier opposition system, pre-grant and post-grant opposition. But that after the patent extended abstract and say extended after that not, that is the corresponding patent specifications, okay, that you have to submit it. That will be put up in the patent office website. That will be, say, ultimately people will get the information regarding your invention throughout the world. So now any persons can ultimately challenge your invention on the opposition ground that this is not a novel invention. So the novelty part is essential and we have already circulated a documents to you. You say that what you may ask me where from I can get the search for the novelty. Specifically lots of corporate people they have say paid search databases, but say that paid search databases made based on the open source open databases of the patent office. So just like how, so we have provided the databases for you, databases websites for the patent office and also other sites also. From that you can say design your invention nice way. Just like say here, I can say that I can simply suggest 2 things here. How can you do a novelty search part? Just like say based on my prior experience from patent office, what we can do that just like we can narrow down the inventive areas of your invention just only from based on 1 or 2, 3 keywords. Just like you are following problem solution approach. So from you can generate the keyword based on your solution, what solution you are providing based on the existing problem. Because invention somehow you are solving some problem, so with respect to existing prior art. So that way you can design nice way your say novelty search option that which madams will show you in the next presentation how to do a patent search options. Then we can again search take another criteria called non-obviousness criteria. This is also well debated nowadays. Throughout the world also, just like people are thinking about 2-tier patent systems, all sorts of things. Just like here also, we sometimes, just like for novelty, if I get all information, all inventive features of your invention in a single prior document, in say prior published document, then it will destroy the novelty. But say, if I got some part of your invention in one document, some part of the invention in another document, and say a person in the skill, just like ordinary person, can combine these 2 prior art and tell that your invention is obvious. So that part is taken care of by non-obviousness. That part we generally take care based on, say, considering ourselves within the persons or within the footing of average person skill in the art, or sometimes we take care of the different prior art and try to club that what way that club prior art that will suggest the inventive features of the invention, whatever you have submitted in the extended abstract form. So that part we take care of by non-obviousness. Then industrial applications, that is another of the criteria for an invention to get patents. This criteria is almost throughout the world. Okay, but standards may differ from jurisdiction to jurisdiction. Okay, so that is the 3 criteria that our legal group just like another group people take care of the 3 criteria. Along with that, we take care of another thing, just like a few inventions which are not given patents in India, considering the social economical condition in India, just like agricultural method of treatment, computer program per se. That part I will come to later on. So just like say, these are the 3 criteria part. Another group of team members, they evaluate, and based on that, okay, again you may ask me that, okay, just like say whether based on that what benefit I will get it. Okay, something is just like your thing is not novel, but how can you further mold your invention to make it novel? How can you further mold your invention to make it to qualify for non-obviousness? Ultimately, your invention is not applicable for industrial application. Then how can you make just like utility criteria within that invention? That will help you to just like to ultimately further sharpen your inventions. Okay, that is the benefit for the inventors per se. Just like maybe this is not saying first go, it is not qualified by the review process. But further, if you do the research on that part, definitely within a 6 months or 5 months, you will come up with a better invention. Because I will give you a search with reference to novelty, at least 2-3 patents which are same or similar to your invention. Based on that, you can further iterate your brain and can nurture the process parameters or composition parameters little bit, and you may come up with a better product than whatever you submitted in your extended abstract. That is that we are feeling this time already. Just like last time we filed 100 patents, but this time we are giving just like a quality review, quality feedback to the persons who is availing the patent drive program, and based on that we are getting also good invention. So that is the objective also for the patent drive part also. Now let's see, I will just show you a few legal provision on that part. Come to next part. Just like a hot way, court tell about this will help you little bit to understand that the legal aspects of that. What a court looks out, that what they are telling industrial applications. What they are telling an invention shall be considered as susceptible of industrial application if it can be made or used in any kinds of industry, including agriculture. So they put it out agriculture within the purview of industry. Just like say your device, your equipment, your product is say susceptible, or sometimes we use the word capable of capable, then that's it will qualify for industrial application. Okay, just now I will show you few part. So novelty part, how you can destroy. Just like based on prior publications, based on prior oral disclosure, I will show you few case study here. There also how based on oral disclosure also that may lead to the destruction of the novelty of your invention. Okay, then based on prior importation, just like say you have prior importation, already you are considering one patented product or patented product that is already maybe imported by somebody else. Prior knowledge, then prior working, that also lead to the, let's say you are, before filing the patent application, you worked in a public place about your invention. Just like that is our objective. Just like thesis is coming up, what will happen that say lots of people will ultimately display their invention in that particular program. So before that, if you consider you just approached this particular platform, then you will get two times return. Just like you will get maybe IP, and based on the IP after filing, then you can go and showcase your technology and get a thesis awards also. That is the benefit of the IP system, beauty of the IP systems. Okay, so that way that lead to prior public use, prior public exhibitions, prior public knowledge, that lead to the destruction of the novelty of your invention. Because you may ask me how can you, how that thing will come up. I'll show you a few cases, how this thing has also happened. Just come back to the, okay, let's say a few cases. Patentee claimed an imported ballpoint pen in a which the housing around the ball had a groove running in ring below equilateral plane of the ball. This produced a smooth flow of ink. Before filing the patent application, the inventor gifted the pen to 3 of his friends who were free to use this pen as they wished. Okay, just like they told that you can freely use this pen, used. So now that friends ultimately suggested, when the patent application filed and others round of novelty has come up, the prior use ground, ultimately, based on that, his patent has not been granted. So it was considered the prior working. The court analyzed the two part here, just like say, he has told his friend to use the pen freely. He's not in confidence. Based on that, yes, he suggested to freely to use. So then, if it is a confidential disclosure, it's a private disclosure, that may be different. But it was stated free to use and gifted. So considering that, it was considered the novelty was lost. Come to the second part. Just like say, patent related to laser apparatus used to alter the shape of a cornea to correct myopia, hyperopia, and astigmatism. The defendant, just like how defendant means, let's say in opposition or infringement proceedings, if somebody, you are telling that, okay, you are infringing my patents, that will be considered, just like let's say whom you are filing the suit against, that will be considered the defendant, or in opposition proceeding like this way. So that way, defendant counterclaim for revocation. He revoked. Just like the novelty also ground will be challenged in the patents different times. Just like say during filings, part office patent examiner will check. During after publication, any person interested, any person can also challenge your patents, considering it is not novel. Again, that after grant, post grant opposition, it will be again challenged. After grant also, there is a proceeding called revocation. So here the situation happened, just like in revocation, ultimately you know the incident of our NIM and all the related issues in European and American countries. So there also we challenged the validity of the patent on the grounds of the novelty, means prior working, prior knowledge ground, when we are able to successfully revoke few patent in other jurisdictions also. So that there also that they discussed among doctors before patent was filed, but the defendant could not prove the oral disclosure was not made in confidence. If you consider the disclosure I am disclosing in confidence, that chances made will differ. Okay, just like this way, different kinds of cases you will get it, just like based on prior disclosures to the society without in confidence, that lead to destruction of the novelty of your invention, even including exhibitions without prior notification, prior permission from the patent office and others, that lead to destruction of the novelty of your invention. Let's come to the next part. Okay, this is also another case. Patentee sent his claimed product to a potential customer for testing in a comparison with the other member. Other suppliers were present during the test which has been arranged. The validity of patent was challenged later on the basis of availability of members of public before the date of patent. Then they are able to prove that this is simply for experimental purpose. Just like a, see, you getting different types of things. Here he somehow able to convince that this is in confidence and only for experimental purpose. So it did not ultimately destroy the novelty purpose. So say situation differs from different to part. Just like in free to use, in confidence, that part sometimes in differs. Just like in our exhibition, most of the cases we consider the three kinds of situation. All others, say players involved, players and others also able to see and your invention. Those players ultimately later on may anticipate that this is not a valid invention on the grounds of novelty. Okay, come to the next part. Just regarding the inventive stage requirement, non-obviousness requirement, just what is the present law with reference to the India, how they judge the non-obviousness criteria. See that this is one of the, say, landmark judgment. How they are judging the improvement, just like what you are telling, patent for invention is mere an improvement. With reference to what? Existing art. Just like say consider what way, just a simple here, just like what way, just think about how can we generate the invention here also. Just like we are using the here LCD, what type of presentation here. Just like say how can you consider that will also be just like say convert into a two-dimensional part. How can you convert that into three-dimensional part? When the three-dimensional part will ultimately 3D movies kinds of 3D presentations will ultimately how that is improvement. 3D something 3D part is improvement. Now improvement part, how you decide that will qualify for non-obviousness part. The law suggested improvement on something known but must be more than workshop improvement. Just like sometimes you have sitting in a 4-leg chair or 4-leg chair, you just simply are adding another leg into that to provide some sorts of thing. That may chance that is simply workshop modification, or say simply you are changing the doorknob using instead of metal to other ceramic or polymers like this way for particular purpose. They may consider a workshop modifications regarding that. Then a combination of old integer must produce a new process of an improved result. Just like you are, that day we are discussing somebody, you are telling that okay, I have invented, let's say, pen with stapler together. So that now pen is independently doing some function, stapler is independently doing the function, and you are just like you are combining that functions of the pen, function of the stapler, and it's like okay, I have invented a pen with staplers. So there, I think if you, that your combination do function something different way, then it may qualify for a patentable invention. If not, then it may not qualify because that both are integers are performing independently. You are not getting an efficient system out of those. Only they are doing their own performance. But using that integers also, if you do perform as a better way, then may qualify for it to be patentable. Similarly, that's a mere collection of integers. Okay, same thing. The essential of the test validity of patent is whether it involves novelty and just that part. So, inventive state requirement, we have to consider that it should not be a mere workshop modification. Just like say as a basic class, you may consider workshop modification will be just so that it should not be obvious to the person that obvious to the person's skill in the art. Skill in the art means, let's say, in respect of a particular field, if that say that is also obvious, just because I am simply changing the knob from metal, one metal to another metal. So metal, from the metallurgist's point of view, just like this is obvious. I am just, if you use instead of iron, from irons, let's say iron, cast iron to stainless steels, that's automatically some property improvement will be, property or luster improvement will be there. Though may not qualify for doorknob, may not qualify for an essay to be a patentable invention. Just like I am changing some one metal or one alloy to another alloy, one kinds of situation, that may not qualify to an invention within the patentable invention. Okay, so these sorts of things, just like for novelty, you should consider there should not be a prior art. For of non-obviousness, but just simply rely on that should not be a mere workshop modification, and that should not be obvious to that the persons in that particular field. Come to the next part. Okay, then say these are the different categories of invention which are not qualified to be patentable. Already circulated in your say research publication material. These are the different things. Indian context we define in the section 3. Those are not qualified to be a patentable invention. So these are just like say fabulous contrary to well-established natural practice. Okay, just like say consider okay, just water is flowing from high altitude to low altitude. I have invented a filter system using just like say consider. But different ways, there are some different ways, natural laws, just like say okay, or say someone you are telling okay. Sometime we also discussed in that part. Just because natural laws are there, and you are telling different ways. Okay, water is flowing from low to high altitude without the just like considering other laws, and that is other part without the hindrance of the third, any other forces and any other matters. So that part may be just like say because natural law or say some law has already suggested. So that. Sometimes they are telling that that is not qualified to be patentable. Okay. Then contrary to morality or injurious to public health, just like say something just like say invention related to let's say gambling machines. Okay, that may consider to be say injurious to the public health because that may lead to the destruction of the society and others. So that way not qualified to be a patentable. Then scientific principle, formulation of abstract theory, just like say those part, they are just like some theoretical part and others part, they cannot be qualified. Then mere discovery of new form of known substance which does not result in enhancement of the efficacy of that substance or mere discovery of new property of or new use. Just like here, lots of debate thing is coming out, okay, you are telling that I have come up a new form of known substance without increasing any efficacy on that part, that may not qualify. Then substance of mere admixture, you are mixing salt with water and you are telling that I have prepared a salty waters. So then I think ultimately that if that thing will not qualify to be patentable subject matters, but say salt with water if you give sweet taste, it may qualify to be patentable. But that type of effect you have to prove by admixture, you may generate that I am getting some synergistic effect. That may be qualified to be patentable. Then mere arrangement and rearrangement, you are just changing that leg position or changing the some, just like in your, say, sometimes we call that in your printed circuit boards, you are changing the arrangement and others, some arrangement, but without changing the functionality in that PCB board, then may not be qualified to be patentable. Then naturally occurring microorganism may not qualify to be patentable, but genetically if you just synthesize some organism in a laboratory, may qualify to be patentable. Plant and animal as a whole or part will not qualify to be patentable. In this regard, just like say, whether chlorophyll can be patentable, the questions may arise to you, whether say, arise to you, then that's just, but here I will suggest, chlorophyll you are synthesizing in your laboratory, we can put it to be qualified to be patentable. So there, we help in this regards also something as per law is not patentable. how can you make those inventions to be patentable? Just twisting the language, twisting the scope little bit on that part. On that part, just because plant and animal as a whole, method of agriculture and horticulture, method of treatment of human being and animals is not patentable considering the societal condition of India. Then another thing here I can tell you, method of treatment is not patentable. The law suggested, how can you twist it? System, device, equipment. How your method can be translated into a product, then it's no problem to be qualified to be patentable. That's what we just give you an indication. How can you convert that invention to a patentable invention? Then method of traditional knowledge related invention is not patentable. Computer program per se, computer program as such, as it is, it's not qualified to be patentable. Then algorithm, formulation is not patentable. But how can you convert that patentable? That also we suggest. How can you integrate your algorithm or computer program with an say hardware component and convert into a system that can qualify to be patentable. Just like say consider a source code or algorithm you develop. Based on an algorithm you are operating some hardware component. How you increase hardware component don't require any invention within that hardware component, but based on your algorithm hardware is functioning efficiently. That together hardware and software it can be qualified to a system patents kinds of thing. A system for telemedicine, a system for generating some product, something like that. They are ultimately the product say manufacturing part. You are just like say maybe some algorithm design. Based on that, you are just you are monitoring the qualities of that part. So that also may be qualified to be patentable if you convert your algorithm into a systems kind of. That suggestion also will provide. Okay, so that way these are the few basic elements of our review process. That review process ultimately not to discourage anybody. This review process ultimately it will benefit to the people who are taking the help of this say patent drive program. That how can you change the alters or enlarge the scope of the invention, considering that it will be beneficial for the specifically to the users. So I'm just stating that, I'm just closing it here. Now madams will tell about the patents.